in our reply, in our supplementary case digest, we have referred again. It is cross-referenced, unlike the original submission. So it contains the page numbers of the page numbers in our bundle and in our digest of the cases and of the scholarly articles that we wish to rely on. We have done that so as to try and make the work of the court easier, and to perhaps try and make the material that we have shared with court more intelligible. I'm most obliged.
Thank you.
My lords, my ladies, my lords, perhaps I would begin with the issue raised by Justice of Appeal Kiage on the Constitution of Colombia.
You are addressing us on the basic structure doctrine?
Yes, my lord. My lord, I will address you first on the basic structure doctrine, and thereafter I will address you on the issue of violation of Chapter 6 by His Excellency the President, and then I'll address you on the proposed amendments, whether they should be separate and distinct memorandum questions, and finally I will address you on public participation in the context of popular initiative. I just wanted, the Solicitor General promised that we would address the issue of the Colombian Constitution, and perhaps that's the best place to begin before I tackle the main issue. My lord, it is important to note that the Colombian Constitution, under Article 37, has a provision which allows a constitution to be reformed. The word used is reformed by Congress, a constituent assembly, or by people through a referendum. So that when one of the bodies exercises that right, it is then not exercised by the others. Where the amendment provision is based on purely a referendum by people exercising their power through that process. Now, the next issue on the Colombian Constitution is that it is well known that Colombia is a divided country under war, and that within Colombia you have the rightist militias, leftist guerrillas, and narco traffickers, and therefore their constitution is predicated on addressing those particular issues, and it is therefore an outlier in considering the structure of the constitution provisions. Now, the issue at hand, where the courts carried out a review and declared a proposed amendment unconstitutional, was in connection with the election of a president, which had earlier been allowed contrary to the Constitution. But when it came the second time, the position of the Constitutional Court was that by giving him a second opportunity to violate the term limit under the Constitution, he would be in a position where he would control the appointments to the constitutional institutions by way of having served for unduly long term. And that was the rationale behind that decision. So, my lord, I would humbly submit that the Colombian example would not be an appropriate example to be adapted in our context. Having said that, my lords, I now come back to addressing the issue which is before your lordship, and that is the court's finding on the issue of basic structure doctrine. I will begin by referring your lordship to a matter my learned friend Mr. Ghetto adverted to, and that's the finding at paragraph 474G of the judgment. My lord, you will find this finding in our supplementary record of appeal 1A, and the page I'll refer to is page 179. And that is where the court found that the basic structure document protects the core edifice and foundational structure and value of the Constitution, but leaving open certain provisions of the Constitution as amendable in as long as they do not fundamentally alter the basic structure. That notwithstanding, it proceeded further to state that certain provisions in the Constitution which are inoculated from any amendment at all because they are deemed to express categorical core values. These provisions they termed as being unamendable and also as being eternity clauses. So according to the judges, by applying, notwithstanding the provisions of the Constitution, which I will come to, by applying the basic structure doctrine, some of the provisions of the Constitution will be unamendable and therefore they form eternity clauses. They then went further to determine how these eternity clauses would be addressed. And at paragraph 474E, and that the court will find in the Attorney General's Supplementary Record of Appeal 1A, dated 8th June 2021, they say that the basic structure could only be altered or modified by the people exercising their primary constituent power, which would involve civic education, public participation, debate, consultation, and public discourse, and a referendum. So that there are some core values in the Constitution, never mind Article 155(1), which can only be altered in a constitutional moment. That's what they're finding. Now, it is not in dispute that the common scheme adopted for creating unamendable provisions is by expressly stating them in the Constitution. And my old friend, Mr. Ghetto, outlined some of the countries where their Constitution contained unamendable clauses. And the examples were like Germany at clause 79(3) of their Constitution, France Article 89, Angola at Articles 236 and 237, and many other countries. So the best way of ensuring that you have unamendable clauses is to ensure that they are expressly stated in the Constitution. As stated, it is not in dispute that our Constitution does not have unamendable clauses. My Lord, that was indeed the finding of the learned judges at paragraph 473 of their judgment. And you will find that at page 176 of the Attorney General's Supplementary Record of Appeal 1A. Indeed, the learned judges went further to concede at paragraph 402 that the Constitution conceived in Kenya was a model participatory constitutional building process, and you find that at paragraph 402 of their judgment and paragraph 403. My Lord, each chapter of our Constitution is a product of development and reflection, and thereafter endorsed by the people through a referendum. In fact, the amendment provision at Chapter 16 has its own constitutional history. As you are referred to, I don't need to read it again. The history of Chapter 16 is found at page 47 of the CKRC report. And my Lord, that you will find in your record at page 1080, volume 3 of the Attorney General's Bundle of Authorities dated 9th June 2021. And my Lord, my ladies, the other provision dealing with history of the amendment chapter at Chapter 16 is found at page 76 of the CKLC final report. And you will find that in pages 1082 to 1083 of volume 3 of the Attorney General's Bundle of Authorities dated 9th June 2021. So the chapter on amendment collected the views of the people of Kenya, was debated, a finding was made, and the text was then formulated. In fact, it is conceded again in the judgment by the learned judges at paragraph 427, and you will find that at page 158 of the Attorney General's Supplementary Record of Appeal, 1A, dated 8th June 2021, that the draft constitution that emerged in October 2002 was a reflection of the true will of the Kenyan people. And that is what has been reflected in this constitution. At the end of it, there was then the draft by the CKRC, and it is the provision in that draft that was then incorporated into the WACO draft at Chapter 19. And that is found at page 1978 to 1980, volume 4 of the Attorney General's Bundle of Authorities dated 9th June 2021. What is clear in that bundle is that it mirrors almost word to word what is contained in the current constitution. Again, when it came to the harmonized draft, the same Chapter 19, which was incorporated into the WACO draft, was once again incorporated into the harmonized draft, and you will find the harmonized draft at page 2266 to 2669 of volume 4 of the Attorney General's Bundle of Authorities dated 9th June 2021. At the end of it, there is no doubt whatsoever that Kenyans have had no dispute whatsoever or controversy as far as the amendment and presentation of the view of the Kenyans on how they want their constitution to be amended, and the view taken with
You are watching TV 47, the home of Untold Stories.
Look at the history, it is very clear that the issue of entrenchment through express provision was considered and not found appropriate. Yes.
Mr. Oraro,
Yes, madam.
you say it was considered and not found appropriate. That's an important submission.
Yes.
Are you able to point out where exactly it was considered and rejected, found not appropriate?
My Lord, if you look, page 76 of the report of the Commission states as follows, that the new constitution should have some entrenched provisions, for example, in human rights, that Parliament does not have the power to amend. The new constitution should address the issue of relationship between the various organs of state and must deal with checks and balances. The new constitution should have supremacy clause that could state that the constitution is binding all the people and all organs of state. The constitution should only be amended by at least 75% of the members of Parliament, and the amendment procedure should make the following distinction, and the distinctions are placed there. And then the considered non-entrenchment but special provisions and the bill, which would require amendment of the provision. So at that page, the Commission considered the alternatives to amendment of the Constitution and eventually came up with the formulation which is now contained in the Constitution. So entrenchment was not an option. It was how to secure an entrenchment through an arduous procedure, and which involves various organs of the state and the people.
Do we have an express rejection of an attempt at entrenchment?
My Lord, I think when we read the meaning of the recommendation at page 76, it amounts to very implicit intention not to entrench it in the context of express provisions in the Constitution. Because if that was the position, then they would have, in fact, the first issue was a bill seeking to amend an entrenchment should not be passed unless, and therefore the entrenchment was through making a provision that nevertheless we should have an arduous process of ensuring that any amendment which goes to the structures which are created in the Constitution are passed through a very arduous process. I think that was the intention. And indeed, it was then reduced to a draft. And that draft has remained consistent, and more importantly, the people of Kenya have endorsed that draft in a referendum. So it has been expressly accepted by the people of Kenya. Now, my Lord, I had as I was saying, I'll go through the rigorous process which was then proposed and endorsed by the people. My Lord, in endorsing that rigorous provision, it was clear that it was not the intention that there should be some form of external application to the Constitution of Kenya, which would limit the power the people had granted to themselves. And in considering this, we should take into account that amendment provisions in the constitutions are not polymorphic. Every constitution has its own amendment procedure, and none is like the other. In fact, the text of our amendment is unlike any other constitution. And it is with this in mind that the Supreme Court has consistently warned of the danger of mechanistic approaches to the adoption of foreign jurisprudence and foreign principles, as it underscored in the case of Jaspir Singh Rai and Priya versus Talochan Singh Rai. It is found in our list of authorities at page 332, volume 7 of the Attorney General's Bundle of Authorities dated 9th June 2021. And this is what the Supreme Court said. In the development and growth of our jurisprudence, Commonwealth and international jurisprudence will continue to be pivotal. However, the Supreme Court will have to avoid mechanistic approaches to precedent. It will not be appropriate to pick a precedent from India one day, Australia another day, South Africa another, the US yet another, just because they seem to suit the immediate occasion. Each of these precedents has its place in the jurisprudence of its own country. A negative side of mechanistic approach to precedent is that it tends to produce a mindset. If you have not done it before, why should we do it now? The Constitution does not countenance such a predetermined approach. All the cases cited in this matter were subject to an inquiry into the respective context. We sought to find out whether they are still good law or have been overturned. We did all this because our progressive needs under the Constitution are different, and there is the need to bear in mind that our Constitution remains always, as our brother Judge Ojwang had emphasized, a transformative charter of good governance. So as we look at this constitutional principle, which incidentally is being applied for the first time in Kenya, applying the basic structure doctrine to a constitution which is predicated on amendment by a referendum, is being applied for the first time in Kenya, in the whole world, based on constitutional theories. I mean, the court itself was conscious of the necessity not to blindly apply foreign concepts, and it stated so in the case of Gitarau Monya and Dixon Mwenda Gethinji at paragraph 399D of their judgment. And you will find that at page 147 to 148 of the Attorney General's Supplementary Record of Appeal 1A, dated 8th June 2021. Now, in going through the judgment, you will not find any place in the judgment where the court clearly analyzed the provisions of Chapter 16 against the basic structure doctrine, which they have found to be applying in Kenya. My Lord, in order to do that, it is important to go on to the Constitution itself. My Lord, we begin with Chapter 255(1), which provides a list of matters in the Constitution which must be subjected to referendum. Unlike many constitutions, our Constitution clearly specifies those parts of the Constitution which can only be changed by referendum. And in such a referendum, my lords, my ladies, Article 255(2) provide that the amendment can only be approved by 25% not of voting but registered voters in at least half the counties, and must also be supported by a simple majority. This is much more exacting than the standard set for election of the president at Article 138(4). And indeed, it is a procedure which is much more rigorous than we adopted for the passage of our current constitution. So you begin with that at the threshold of a referendum. Now, it goes further to state that the matters specified in Article 255(1) can either be initiated by Parliament or by Parliament and the people. And it's important to appreciate that popular initiative, unlike the popular initiative elsewhere in the world, in Kenya, it is an initiative by Parliament and the people. And therefore, it is an organ of the state and the people involved in initiating such an amendment. Now, to begin the process, it is provided that popular initiative must be proposed by at least 1 million registered voters. Again, very important to emphasize that the 1 million threshold has only been applied for the first time in Kenya. Everywhere else you have 100,000. I think Switzerland is 100,000. Other countries are perhaps less. But there is no country in the world which puts a threshold of 1 million as the commencement of a process towards popular initiative. Then it requires the signatures of those 1 million people to be verified independently by an independent commission established under the Constitution, and that's IEBC. That is at Article 2574. Then, once it has been verified, then it now goes to the second level of governance. It is then required to go to the county assemblies for consideration. Article 2575. In going through county assemblies, it is important to take into account that the county assembly are required to ensure that any legislation they pass is subject to public participation. Then, if a half the county assemblies pass the bill and provide a certificate to the speakers of the two houses of parliament, then the two houses of parliament will then debate and either pass or reject the bill, and that is found at page 576. And I would like to emphasize that as a precursor to passing the bill, the County Assembly, Article 196.1, requires them to hold the deliberations and in an open manner and facilitate public participation. And Parliament, when it reaches Parliament, Article 2562 requires Parliament to publicize the bill and facilitate public discussion. So at all these levels, there is a requirement for public discussion. Then, if both the houses pass the bill, it is taken to the President, who takes it to the IBC for referendum. But if one house does not pass the bill, then it is then taken to a referendum in any event. That is under Article 257.10. However, if both houses don't pass the bill, then it is not taken any further. So that is why this is a process which is through the people and with Parliament. But it is important also to take into account that the judiciary is not left out in this process. The judiciary has still got its obligation under Article 258 to ensure that these processes are conducted in accordance with the Constitution. In the result, we have a process which is in conformity with Article 11, 12, and 13 in an amendment provision which can only be carried out if it affects those matters specified in 255.1 through the sovereign power of the people and involving all organs of the state. And that's how this very unique amendment provision was incorporated, and it is clear that Kenyans wanted to incorporate an amendment provision which suits their circumstances. Now, my lords, my ladies, if there was any doubt as to the robustness of a referendum, I think the testament is on the rejection of WACO draft, which the executive tried to push through without endorsement at various levels, and the people exercised their sovereign power to reject it. You don't need the court to reject it. The origins of basic structure doctrine. The basic structure doctrine is a constitutional theory which has existed intellectually and has been debated for a long time. But it received its validation through the case of Kesavananda Bharati versus the state of India.
State of Kerala?
Yes, state of Kerala. Thank you, my lord. Sorry. And my lord, in that case, the Supreme Court held that the power to amend the Constitution did not include the power by the Parliament to alter its basic structure or its framework. Of note is that the decision was predicated on the power to amend by Parliament, which was a similar provision to our repealed Kenyan Constitution. And therefore, it was a power exercised by a constituted organ of the state or under the Constitution, and not a constituent organ. While the doctrine received endorsement in Bangladesh, it has faced stiff resistance in other jurisdictions, including Malaysia, Singapore, Pakistan, Sri Lanka, Zambia, Uganda, Tanzania, South Africa, and many others. Indeed, an implicit power to limit the power of amendment in the Constitution has faced stiff resistance even where the power to amend is solely in Parliament. So it is inconceivable that we can attempt to incorporate the doctrine in a situation where power to amend has been conferred on the sovereign power of the people. The doctrine has fallen for consideration before the recent decision in two earlier decisions by the High Court. And that was the case of Timothy Njoya versus Attorney General, and that is found at page 159 of the Attorney General Supplementary List and Bundle of Authorities dated 28th June 2021, where it is important to note that the court the doctrine found that in view of the provisions of Section 47 of the then Kenyan Constitution, the repealed Constitution, there was no necessity of importing doctrine, but then nevertheless, the court approved the dictum to the extent that Parliament did not have power to amend the basic of a constitution. Since then, we have gone beyond that, and we have now placed that power of the people through referendum.
Senior counsel, did
Yes.
that
Yes.
define it consider the basic structure was?
All it dealt with, it didn't define basic structure as such, but it dealt with basic structure as a limitation to for the power of Parliament to amend a constitution. But proceeded to find that in Kenya we were not dealing with amendment, we were dealing with a review, and therefore it didn't apply in the context of the issues arising in Kenya at that time. Yeah, but it didn't define exactly what the basic structure was. And it has to be remembered, my lord, that the Casavananda case was not a case on amendment of the constitution as such. In fact, it arose out of a struggle between the Indian Parliament on issues of land and the Supreme Court. The Indian Parliament was trying to take out the entrenched provisions which protected land tenure in the state. And therefore, the Supreme Court deemed this to be amending a provision which affected the basic structure of their constitution.
As senior counsel, in your view, what is the contextual relevance, similarities, or differences between the Indian Constitution, the Kenyan Constitution, in relation to the Casavananda case?
There's no similarity at all, because first and foremost, India is a federal state. Secondly, the Constitution of India was a negotiated constitution out of the Westminster system, which has been amended from time to time. Thirdly, the Indian Constitution is predicated on the power of amendment conferred to Parliament, which is a constituted power. It doesn't give the Indian people the right of altering any provisions of the Constitution through a referendum. So it is a completely different circumstance. And lastly, it has to be remembered that the Kenyan Constitution is not just an issue of a referendum. The Kenyan Constitution incorporates every organ of the government in the process of implementing popular initiative. The electoral authority, it involves the county government, it involves Parliament, it involves the President, and it involves the judiciary. That is not the situation in India. So Casavananda cannot apply in our circumstances. My Lord,
Sorry, Counsel.
Yeah.
I'm just wondering,
Yes, my Lord.
from where you stand,
Yeah.
is it your position that there are no parts of the Constitution to amend which will be to significantly alter its character?
My Lord, I would approach it from...
Let me just finish that thought.
Yeah.
For example,
Yes.
the Constitution says that there shall be 290 parliamentary seats.
Yeah.
Altering that from 290 to 230, or well, 230 or 330,
Yeah.
is it the same as altering it to say that there shall be no parliament? I mean, that's crazy, but supposing someone would come up with an amendment to say that parliament stands suspended for a while, and you go through the motions of amending it, would you say that the two amendments are the same so long as the process is followed?
My Lord, they are not the same, but the Constitution has provided a procedure for dealing with that issue. The Constitution has provided a procedure, and that procedure has to be strictly complied with. And if it is complied with, then it protects the people of Kenya fully.
Mr. Warero, that's my question.
Yes.
Supposing
Yes.
you follow the procedure
Yes.
that is set out in the articles you refer to.
Yes.
You have whether a parliamentary initiative or a popular initiative.
Yeah.
You take it through, you pass the draft, it is sent, the bill,
Yeah.
it is sent to the houses of parliament,
Yeah.
it is sent down to the county assemblies. You actually go ahead and have 1 million signatures, and then you go to a referendum, and you pass that parliament shall not exist in this country.
Yes.
Does that not alter the basic structure of the current constitution to the effect that, let me finish, to the effect that one might say what you are doing is not just amending the constitution, but basically altering it, totally changing it to something else?
My Lord, it would be an alteration, but our Constitution has provided for it. And what we are objecting to is borrowing a foreign doctrine to substitute what our Constitution has provided for. It has provided for sovereignty of the people. If the people of Kenya don't want a parliament, you can't stop it by applying the doctrine. Because the people of Kenya have said, you want to alter the structure of our Constitution, come back to us. And that is what we did by passing the 2010 Constitution.
Sorry, I'm taking a bit of your time. Let me just follow that a bit.
Yes.
Is it not the thinking of the judges in the court below that if you want to do that fundamental change of that nature, it's okay, but beyond following what is in 255, 257, you must also ensure there is real public participation. You must ensure that there is civic education, and you must ensure that there is a constituent assembly. So they will still have their way. They'll have their way, the Kenyans will, but not merely by way of parliament and referendum, that there has to be something more. Isn't that what they're saying?
My Lord, that is what they're saying, but it's contrary to the provisions of the Constitution, because the Constitution has by itself provided the manner in which the public must be involved prior to a referendum. And it includes, 1, at the county level, 2, let me just get my Constitution, my Lord. My Lord, if you look at 256(2), it is the only other time, while there is the general obligation of Parliament to encourage public participation, 256(4) is the 256(3), 256(2) is the only provision in the Constitution which wants Parliament to publicize the bill, to amend the Constitution, and to facilitate public discussion. It is the only one. Yes. So we have provided for it in our Constitution. Why then would judges decide that they are placing a threshold on how an exercise which has been fully provided for in the Constitution can be carried out? Now,
Senior, before you proceed on.
Yes.
Don't you think that is the reason as to why we are all gathered here?
Yes.
Why we are all gathered here?
Yes.
The court said that a certain procedure or an aspect of it touching on public participation was not followed. But your argument is the public participated. You can.
My Lord, I am saying that the public have a right indeed.
Yeah, thank you. I'm just following up to what my brother here has said and what his senior has. You can't hear? Okay. Yeah, what I'm saying is, from what he has explained, following up to what my brother judge put to him, is indeed that the reason as to why we are here. If I have understood the judges of the High Court well, that the public participation was not followed. And you are saying they were satisfied, or their rights were not trampled upon. Is indeed that the sole reason as to why we are here?
Not at all, my lady. The reason we are here is because the judges in the Superior Court, instead of determining whether the provisions of the Constitution had been complied with, have unilaterally set a standard. And that standard is a standard for a constitutional moment. They now want that before any constitutional amendment is made,
before any constitutional amendment or any touching on the basic structure?
In order to find whether it touches on the basic structure, they have set a standard which requires the court to examine it and find out whether it touches on basic structure or not. If you find it doesn't touch on the basic structure, then you can now go and affect it. But if it touches on the basic structure, then they have completely ignored the provisions of the Constitution and come up with a standard which is consistent with the standard we adopted for constitutional review, and which is civic education, public participation, debate, consultation, and public discourse. And that's why we are here. Had they merely said there is a right for public participation under the Constitution, it has not been conducted, we won't be here, because it would be consistent with the provisions of the Constitution. My lady, have I answered you? Thank you. Now, my lord, my ladies, this issue came again for consideration in the case of Commission of Implementation of Constitution versus National Assembly. That is found at page 4238, volume 8 of the Attorney General's Bundle of Authorities, dated 9th June 2021. I was in that case. And my lord, that case again was an attempt by Parliament to amend the Constitution, which could have affected the basic, structure, my lord. And in that case, the position taken by the court was for the parties to wait for the bill to be passed, and after that, if they felt the basic structure was affected, come back to court. So it was not dealing with the situation which we are dealing with, which is an amendment by popular initiative through a referendum. It was again dealing with amendment by the Parliament. My Lord,
Senior Counsel, as you proceed, I need to remind you about the time.
Yes, my lord.
Because the 2 hours allocated to Mr. Ogeto, you can see it's only 37 minutes to go.
Yes, my lord, of course, it is important, and I humbly request we address any issues raised by your lordship so that we can all live with a clear mind. And that has taken a bit of time. Be that as it may, we have 30 minutes more donated by the President's team.
All right, carry on,
Yes.
provided you remember that. Thank you.
Yes, my lord, this issue, the issue of the amendment provision has come for consideration before a 5-bench of this court in the case of Senate and 48 others and Council of County Governors and 54 others. You find that at page 88 of the Attorney General's supplementary list and Bundle of Authorities dated 28th June 2021. And in that case, in fact, this court considered Kasevananda and found at paragraph 50 that in this matter, Article 255(1)(1) of the Constitution expressly states that any alteration to the objects, principle, and structure of devolved government can only be done by way of a referendum. That answers the question of what do you do with basic structure in Kenya. In fact, the court said that in India, it would be unconstitutional. But in Kenya, you can pass it through Article 255(1), and thereby disavowed the whole of this concept of basic structure. My lords and ladies, the issue again came for consideration in the case of Non-Governmental Organization Coordination Board and 5 others. That is found at page 40 of the Attorney General's Supplementary List and Bundle of Authorities, dated 28th June 2021. And again, there, Lady Justice Nambuye clearly said the Constitution itself has provided for methods for such entrenchment. Article 255(2) makes provisions for an amendment to the Constitution through a referendum. Article 256 through legislation, and Article 257 through popular initiative. None of these cover judicial pronouncement. And that's what the court has now done. They have now said, before you do any amendment, come to us. Now, again, it was considered by this court in a very serious case where some people in Kenya wanted to secede. And my Lord President, you are in that case. And again, it was clearly held by this court that in view of the foregoing, the apparent conclusion that the respondent's agenda for secession is unconstitutional has no basis in law. The respondents have a constitutional right to demand secession, but can only be done within the confines of the Constitution as stipulated under Articles 255, 256, 257. They now want us to address the issue through an academic doctrine which has been validated by the Supreme Court of India. Now, my Lord, therefore, it is obvious that Kenya opted for a strong amendment power instead of entrenchment of the provisions which affect the basic structure. Now, my Lord, the issue where there is a referendum provision and an alteration to the Constitution has been effected, has been my Lord, I am told that some of the respondents will have decided not to address the court and would wish that this issue be addressed exhaustively. But when we exhaust...
Sorry, I didn't get you, Counsel.
My Lord, I am told
Yes.
that two respondents have indicated that they will not address the court.
They will not?
They will not address the court.
Okay.
Yeah, and therefore, any time they would have been given, be applied towards addressing this very serious issue. Okay. Yeah, so they say, my other friend tells me that they can offer 20 minutes of whatever time you give them. But be that as it may, we have not run out of time. Let me address this issue.
Well, we had said that you can rearrange yourselves in such a way that one or two of you covers the substantive issues.
Yes.
I believe the basic structure doctrine is a major component of this appeal.
Yes.
And so you have a few more minutes, so just finish.
Yes. So, my Lord, again, in this case of secession, the court very firmly affirmed that you can even secede from Kenya so long as you comply with Articles 255, 256, 257. And that is found at page 32 to 33 of Attorney General's Supplementary List and Bundle of Authorities dated 28th June 2021. Now, my Lord, let's look at it from the other angle. How have other countries dealt with amendments carried out through a referendum? And in respect of this, I would like to refer you to the thesis by one of the leading scholars on the doctrine of constitutional amendments, and that is Yaniv Rosnai. And in his works on constitutional amendments, which you find at volume 1 of the Attorney General's Bundle of Authorities dated 9th June 2021, he refers to the reaction of countries to a challenge to an amendment which has been carried out through a referendum. And his first example is found at page 163, and that refers to the French constitutional change. And he says, the French Constitutional Council, which held that it has no competence to review laws passed by people in referendum. In that case, General de Gaulle passed a law through a referendum, Then it was taken to the Constitutional Council. But the Constitutional Council proclaimed that the power of the people is above everything else. And once a matter is passed through a referendum, the court has no basis or authority to question it. And hence the saying in French, le peuple roi. The matter again came up for consideration before the Irish Supreme Court, and that is found at page 164 to 165 of volume 1 of the Attorney General bundle, dated 9th June 21. And the Irish Supreme Court held that people and not God are the creators of the Constitution and the supreme authority. Hence, amendment made by people become the fundamental and supreme law of the land. You can't question it. You can't deny the people the right of having a referendum. It is their government, it is their law. Again, it came before the Romanian Supreme Court, and you will find that as page 165 of his writings, and he says, the Romanian Supreme Court held that once an amendment is adopted by referendum as required by Article 151, it is definite and final, and the court has no control over it, since such a law expression of the original willpower is above the will of any power. So where you have a referendum, the courts cannot intervene. Now, in this article, Rosny, who is a real adherent of the structural doctrine theory, nevertheless states at page 158 as follows: just as in material science, a solid material can exist in multiple forms, so does the amendment power. Constitutions have different procedures for constitutional amendments. Not only do entire constitutions differ from one another in mechanism, actors, and procedures, and ours is unique in the world, procedures involved in the amendment process, but also the same constitution might incorporate different procedures for amending different provisions and principles, like in ours. This section therefore argues that one ought to regard constitutional amendment powers not in a binary manner, limited and limited, but rather as a spectrum of scope, a spectrum of amendment powers. The more similar the democratic characteristics of the secondary constituent power are to those of the primary constituent power, strong amendment power, the less it should be bound by limitation, including judiciary, scrutiny, and vice versa. That is really the principle which ought to apply. And in considering this, a leading professor in Hong Kong, Professor Pojen Yap, in his work, The Conundrum of Unconstitutional Constitutional Amendments, has this to say. You find that at page 22 of the Attorney General Supplementary List and Bundle of Authorities dated 28th June 2021. The people may not be always right, for popular sovereignty is not an absolute guarantee of substantive justice, but neither are the judges infallible in their moral deliberations. In these circumstances, the judiciary must cede to the expression of popular sovereignty. Judiciary must concede to the expression of popular sovereignty, not merely because the amendment is an unmistakable expression of public will, but because this convergence of interests is undisputable evidence of the triumph of the political process over the intervening institutional and electoral barriers erected by separation of governmental powers. Very profound ones. In the result, it is my humble submission that the doctrine of basic structure was not intended to apply to our Constitution. And just to give a very short summary, it applies limits to the power of constituted powers, and that is the Parliament, and cannot apply to amendment by people through a referendum. There is an academic debate out there, but it remains academic. It has not been applied anywhere in the world. Whether the basic structure doctrine applies to Kenya would be predicated on the form of amendment power as contained at Chapter 16, and it is obvious that Chapter 16 does not envisage any limitation. Further, our textual and historical analysis clearly show that it is not intended that there ought to be limitation in exercising the powers granted under Article 6, Chapter 16. Finally, my Lord, the Superior Court has arrogated to the judiciary the right of determining what forms basic structure and what can be amended and what cannot. A power the people of Kenya have given to the people and all the organs of the government. Now, as a result of this decision, it is being contended that that power can be exercised by judiciary and judiciary alone. My Lord, in substance, this would amount to a repeal of Chapter 16 of the Constitution. And this could not have been the intention of the people of Kenya. My Lord, therefore, it is my humble submission.
Senior Counsel, before you finish on that argument.
Yes.
One of the submissions made by, one of the grounds advanced by the respondents in their submissions is that the appellants are applying what they have called textual interpretation as opposed to the holistic, purposive interpretation in the argument that as long as our Constitution provides that all parts of the document, of the Constitution are amendable, we should abide by what the Constitution says. So they fault the appellants for what they term as textual reading or interpretation. What would be your comment for that?
My Lord, I have analyzed the text. I have also analyzed the textual consideration of the court by taking into account that this is a provision which involves all the organs of government established under the Constitution and then reverts to the sovereignty of the people. That is, the real spirit of the Constitution is contained in Article 1, and it states that the people may exercise their sovereign power either directly or through their democratically elected representative. My Lord, through their democratically elected representative, this right is being exercised through the proposals, the county governments, parliament, the president, but it ends up with direct exercise by the people of their sovereign right. And that's what defeats all these arguments. Here, we are being placed in a situation where from time to time, people who have their own inclination on any amendment proposed can go and stop it and deny the people the right of making a decision. It is the right of people of Kenya to make a decision, and they have reserved that for themselves. And I have also analyzed the various institutions which are involved in the exercise of this power and how they engage the public in ensuring that they participate and debate the process before they exercise their power. And finally, if that is not done in the spirit of the Constitution, I have also said the courts remains with the power to ensure, and it is a very wide and permissive power, to ensure that the spirit of the Constitution is carried out within the context of the provision. So one cannot say that that is a textual analysis of the provisions. And we have not gone on to the whole Constitution and seen how it relates to this. But more importantly, history informs us of how this provision came into being.
All right, thank you. Thank you, Senior Counsel.
Thank you, Manoj.
Moment before you sit, Senior Counsel.
Yes,
you made a strong submission to the effect that once the people have decided, what they have decided is binding and really nothing matters. No one, the court cannot go against that.
No, Manoj, what they have decided, the court has power. But the power granted to the court is on interpretation.
That's okay.
Yes.
And then you said that, in fact, that you seem to suggest that that is the policy, that is really the position worldwide. I'm looking at Dr. The gentleman that you quoted. You call him an authority in this area. In fact,
Rosnine.
Yes, indeed. In fact, your first authority on the part of the Attorney General is actually his PhD thesis.
Rosnine is another end of basic.
Yes, exactly. His entire thesis is here, titled Constitutional Amendments, a study of the nature and limits of constitutional amendment process, powers. Now, he talks about the case of Switzerland.
Yes.
And in Switzerland, what he says is 100,000 people, by way of referendum, they moved to say that any refugees who come to their country should be deported at the border without a right of appeal. Clearly, that was against the principle of non-refoulement. Now, when this matter came to the Federal Council, which really is their highest authority, judicial authority, the judicial authority actually said that that wasn't right. Because even though the people had spoken, that which they proposed was actually against a principle of international law, and so they proposed to Parliament, to the Federal Assembly, to reverse the will of the people. So the court said, what the people have said goes against international law, and therefore it cannot stand. Do you find this an aberration?
My Lord, I don't find it an aberration, because that came after the people had expressed their will. The people have to express their will. And when it comes to enforcement, then in our jurisdiction, the court has very wide powers of interpretation and to enforce fundamental rights. So if there is a constitutional provision which has been passed and violates certain fundamental rights, then the court will interpret it in that context. But the court cannot deny the people the right to decide whether there should be the amendment or not. Yes.
Okay.
Yes. Thank you, my Lord. My Lord, I have two other issues to address very quickly before I leave for my another friend, Karori Kumau. My Lord, the next issue I want to address very quickly is the issue of the presidential liability and for violation of Article 73A1. My Lord, I want to say very few words on this. I merely wish to say, my Lord, that Article 73.1 is aspirational. It sets out the general principle and statement of policy to signify the value system, ethos, and cultures which are expected of state officers. The liability for violation of those principles are contained at Article 75, both for public officers and for state officers. But the president and many other officers, including that of judiciary, is a tenured office. And in every tenured office created by the Constitution, a provision has been made for how to deal with their violation. My Lord, and for President, in the event he violates any provision of the Constitution, the path is impeachment by Parliament, not the courts. Just like, my lords, judges cannot be tried for violation by the court. They have to go to a tribunal set up under the Constitution. It is therefore my humble submission that this finding was against the Constitution. My Lord, I will move to my next subject, which is whether proposed amendments needed to be placed as separate and distinct referendum questions. My Lord, my first humble view is the judges, having determined that the basic structure doctrine applies and therefore the bill was unconstitutional, ought not to have gone more than that. But nevertheless, they went on to determine the issue of whether the referendum question should be binary or each issue should be on a separate referendum question. My Lord, and in saying this, they relied on Article 257.10. Now, Article 257.10 does not deal with the issue of question of referendum at all. It deals with a question where one house of parliament has not passed the proposed bill by popular initiative. The manner of presenting the bill to the people for a referendum is prescribed under Article 256.6. Now, it states that once the President receives the bill, he has to refer it to IBC, and the sole function of the IEBC is to certify after the referendum whether the bill has been approved or not. The purpose of the referendum is not to legislate. In the result, if the bill is not approved, then that is the end of the matter. Even if some parts are approved and others are not, the bill fails. Like a constitutional bill in Parliament, a bill by popular initiative cannot be amended or approved in part. There's no provision for that. And therefore, by stating that separate questions should have been placed for separate issues on such a bill, the court was actually acting contrary to the very express provisions of the Constitution. And it doesn't matter on whether
Mr. Oraro,
yes.
You said that the court pegged its decision on that point on which article?
Article 257.10.
10.
Yes.
Now, if you look at sub-article 10,
Yes.
what does it say? And I think this is where the judges are coming from.
Let's look at it, my lord. 257.10
Yes.
says as follows. If either House of Parliament fail to pass the bill, or the bill relates to a matter specified in 255.1, the proposed amendment shall be submitted to the people in a referendum.
The proposed amendment.
Yeah.
Not amendments.
My lord, but amendment, whether it is an amendment or amendment, it has by 257.3 to be formulated into a draft bill. So it comes as a bill, whether it is one amendment or many amendments.
And the question is, sir, at Article, and that's what the judges I think seem to be saying, that under Article 10,
Yes.
it is the one question, it is the amendment that will be formulated as a bill and presented to the people. So I think the question that I would assist me at least to understand, why would the Constitution say amendment and not either amendment or amendments?
My Lord, if we read it in context, we start with 3, which says that if a popular initiative in the form of a general suggestion, the promoters of popular initiative shall formulate it into a draft bill. So what goes to Parliament is a draft bill, not amendment.
If you go to Sub-Article 1,
yes.
you in fact will give even a better context.
Yes.
Sub-Article 1 starts with what? It says
Sub-Article 1 starts with an amendment to this Constitution
yes.
may be proposed by popular initiative signed by at least 1 million registered voters.
So we have in Sub-Article 1 an amendment.
Yes.
In between this process through a bill.
Yes.
Then at 10 we still have the same singular, the proposed amendment. So please educate me there.
No, if it is reduced into a bill, then it becomes an amendment. Yes. And it is, the Parliament does not consider it in the context of each amendment as a separate bill. It is considered as a bill, whether it is an initiative by Parliament or by popular initiative. And it is that bill which is then submitted for a referendum, and that bill is an amendment as contained in the bill. That's my understanding of it, my Lord. Yes. So in my humble view, it does not intend to have the question presented as different questions for each issue. My Lord, I've taken too much time and I've eaten into my learned friend's time. I had an issue to address, but I'll skip it. So I will hand over to my learned friend to come out. Thank you, my Lord. Thank you, my ladies.
Thank you, Senior Counsel.
May I please, my ladies, my lords, my name is Kamau Karori for the record. I appear with Mr. Oraro for the Attorney General. Now, mine today will be to address 2 main areas, and these are the question of the popular initiative and the issue of the creation of constituencies. And let me start with the question of the popular initiative, but maybe before I do that, I could just make a quick comment on a question posed by my Lord Justice Musinga regarding her interpretation of the Constitution. And the question, if I understood it correctly, was whether the appellants are engaged in textual reading of the provisions of the Constitution as opposed to a holistic reading. My understanding of a holistic reading of the Constitution is reading the provisions of the Constitution one against the other with a view to creating harmony in what the provisions of the Constitutions are saying. It does not include or envisage reading writings or doctrines that have been developed in other places. It is a reading of the Constitution itself. And so, if you look at the submissions that have been made by Malanet Senior, he has referred to provisions starting from Article 1. He has referred to the provisions of articles dealing with the legislature. He has referred to Chapter 16, the 3 articles in Chapter 16. And so, therefore, that is a holistic reading of the Constitution, and the Attorney General cannot be criticized for not undertaking a holistic reading of the Constitution. Now, that said, let me go to the question of the popular initiative, which has been alluded to by both my learned friend, Mr. Ogeto, and my learned senior, Mr. Oraro. Now, the areas that I'll be dealing with are findings that you'll find of the court from paragraph 484, 491, and 492 of the judgment. And the first issue that I want to deal with are the errors of law contained in the judgments by the Superior Court. The first error that was committed by the court, my ladies and my lords, is as regards the finding by the court that the only people that are entitled to access or to utilize the provisions of Article 257, which is the popular initiative, are those who don't have access to the route through Article 256, that is the route through Parliament. That was a finding by the judges. And that finding, with profound respect, is wrong. And I say so because if you look at the provisions of Article 119 of the Constitution, it provides that every person has a right to petition Parliament to consider any matter within its authority, including to enact, amend, or repeal any legislation. So that even the common man, even Wanjiku was popularly known, has access to the parliamentary route. And therefore, to the extent to which the judgment of the court was premised on the fact that the president having access to the legislature ought not to use Article 257, that finding is erroneous because even the common person himself or herself has access to Parliament. So that is the first error that was made, the presumption that the common man does not have access to Parliament to enact legislation. The second error of law that was that we have seen is the finding that the Constitution under Article 257 does not admit or contain a hybrid initiative. And this you'll find at paragraph 499 of the judgment. Again, this finding is erroneous. And we say so for the simple reason that the provisions of Article 257 of the Constitution do not contain an exclusive people initiative. It is a combination of the people, the county assemblies, Parliament, and then in certain instances the referendum. So that there is no exclusive people initiative that does not include Parliament.
Yes.
Now, in fact, my ladies and my lords, it's arguable, as my learned senior Mr. Oraro rightly said, that where a popular initiative is commenced and then it is not passed by the county assemblies, it naturally dies. And if also it is not passed by the Houses of Parliament, then naturally again it dies. And therefore, it underlines the fact that the procedure under Article 257 is both people-driven and Parliament involvement.
Just wait.
Yes.
Before you move on, you have said, and you mentioned, you touched on the president.
Sorry?
Yeah, you touched on the president, that the provision does not bar the president from initiating. Now, in the circumstances of this appeal, did the president initiate it in his personal capacity or in the official capacity? That appears to be the tension in the judgment of the High Court.
My lady, I'll be coming to that, but
Okay.
the point that I was making at the point on the question of whether or not the president, the finding by the court that the reason why the president should not be involved in the popular initiative was purely because the president has the option of going to Parliament. And the suggestion that was made by the court, not even the suggestion, the finding, was that to that extent, therefore, the president should utilize the Article 256 route and leave the Article 257 route only to those who have no access to Parliament. And the point that I was making is that, in fact, the people have an option of going to Parliament through Article 119. So both the president and the people can access Parliament in that sense.
Now, Mr. Karori, under Article 257(2),
Yes.
A popular initiative for amendment
Yes.
may be in the form of a general suggestion or by way of formulated as a bill. Do you see a situation where those who wield state power can make a general suggestion? To whom are they making that general suggestion?
It's a good question, my lord, and although I was going to come to that, let me just deal with that question now.
Yes.
My lord, the popular initiative route commences once 1 million signatures have been collected. Before that, everything that people will be saying, including the ideas that people would be having, that's not a popular initiative. That's an idea in the mind, or it's a suggestion that you have. It commences and becomes a popular initiative only when you get a million people endorsing the suggestion that you have. So to answer your question, when you say, can you have the president, for example, coming up with a proposal? That is a possibility, my lord. It's actually a possibility that a president can make a proposal that can be picked up and that can be the genesis of a popular initiative. But until 1 million signatures are obtained, it is not a popular initiative. It only becomes popular.
My question is,
yes,
Council, a general suggestion to whom?
My lord, I do not want to hypothesize, but I can, even when you are talking about the general citizen, the Wanjiko, when they come up with a general suggestion, to whom would they be making that general suggestion?
To the parliament, to the county assemblies, etc., to government, to the state.
Yes.
Yes.
And my lord, the president can make a general suggestion or can make a suggestion
to his government,
to the people, to consider an amendment to the constitution. Right. They can make a general suggestion to be considered. And if then it is supported by 1 million voters, it becomes a popular initiative. So, my lord, the fourth error that we have seen from the findings by the judge regards the paragraph 492 regarding the wording of the requirement that the president must refer a proposal, must refer a popular initiative to parliament. There is a suggestion by the court at paragraph paragraph 492 of the judgment, but that's wrong. First of all, the specific article they refer to is Article 257, Sub-Article 5. Now, if you look at Article 257, Sub-Article 5, it says nothing about the role of the president. Article 257, Sub-Article 5 says, if the Independent Electoral and Boundaries Commission is satisfied that the initiative meets the requirements of this article, the commission shall submit the draft bill to each county assembly for consideration within 3 months after the date it was submitted by the commission. There is no reference to the role of the president in Article 257, Sub-Article 5. And therefore, the finding you find in paragraph 492 of the Constitution is erroneous. I then take, my lords, to the question whether Article 257 places a limit or excludes anybody from initiating the popular initiative, which I believe is the question that my lady, Justice Nambuya, was asking me. Now, my lords and my ladies, if you look at Article 257, it does not contain any exclusion in regard to who can commence the popular initiative. In fact, it's our submission that Article 257 is inclusive and not exclusive. And so, my ladies and my lords, the finding by the judges that there are certain people that are excluded from Article 257, the popular initiative route, is not based on the reading of Article 257 of the Constitution, and that finding is wrong.
Now, this Counsel, Justice Tiotia, Counsel. Oh, you're looking elsewhere.
Yes. No, the sound is coming from there. So
yes. Just on what you have just said, if you looked at, refer to Article 255(3).
Yes.
An amendment to this Constitution that does not relate to a matter specified in Clause 1 shall be enacted either by Parliament in accordance with Article 256 or by the people and Parliament in accordance with Article 257.
Yes.
Who would be the people? Who would be the people? And by that, provide us an answer as to who should initiate under Article 257.
Okay. Thank you. My Lord, as I said, the provisions of Article 257 admit of anybody to commence, any voter, any Kenyan registered voter or any person as defined in the provisions of Article 259 can commence the popular initiative route. It's a humble submission that there is nobody that is excluded from the route in Article 257. And there is good reason for that, my Lord. And I was going to, if my Lord would want me to deal with it now, I can, but I was going to come to deal with that issue generally when dealing with comparative examples of how this has been dealt with in other countries. I was going to come and deal with that. But I thank you, my Lord, also for pointing out, and it's something that I was going into, that actually even the Constitution itself envisages that the Article 257 route is a combination of the people and Parliament. And therefore the finding by the judges that Article 257 is an exclusive people route is not correct.
But Counsel, just a moment to follow up on that. If that article says the popular initiative is the work of the people and Parliament,
yes,
does that not mean that in the eyes of the Constitution, Parliament is not the people? We have the people,
yes,
and then we have Parliament.
yes.
So, do you see why there's a problem, at least for me, when you say the people includes everybody, including we, the state officers, the president, parliamentarians, and so on?
My Lord, in fact, if you look at the wording of Article 257, and if you read it together with the provisions of Article 38 of the Constitution, every person in Kenya has political rights that are protected under the Constitution. And those rights include supporting or campaigning for any cause. So that even the officers seated in front of me today, you have a right to vote, you have a right to support any cause. And if that cause includes, for example, a proposal for amendment of the Constitution, you have a right. The President has the right to vote at every election and in a referendum. He has a right to vote. So the political rights in Article 38 cannot be curtailed unless by express words. And that, the rights that are protected by Article 38 include the right to participate in the popular initiative route. It does. So if we are to try and say that because of Article 258, we will find a way somehow of removing the right of public officials or of the President from participating, then what happens to the right he has to vote at the referendum for the proposal that has been put to the people? What happens to his right to support any cause, which is a right that is enshrined in Article 38 of the Constitution? And so the reading of Article 257 as excluding any person would entail denying them the political rights enshrined under Article 38 of the Constitution. So, and then, my Lord, you are referred to by my learned friend to the question of what the framers of the Constitution had in mind. And my Lords, I refer you to the workings of the Constitution Commissions on the Constitution, the final report of Technical Working Group K. You will find this as number 27 in the amended digest by the Attorney General dated 20th of June 2021. Now, my Lords and my Ladies, the purpose of introducing the popular initiative, because this is why it was introduced, is stated specifically. It was to curb the excesses of the legislature. It was to curb the excesses of Parliament. It was not to curb the excesses of any other public official. It specifically identified that Kenyan people said, we want to curb the excesses of the legislature. And hence the introduction of Article 257, the popular initiative route. And the danger, my Lords and my Ladies, in the findings by the learned judge, and I'll just take a minute to explain this. The danger in the findings by the learned judge is this. The framework of our Constitution is such that it is possible that the government of the day might not have a majority in Parliament, which means then the enactment of its laws might be prevented because Parliament may not be supportive of the government. And therefore, the very danger that was supposed to be prevented, which was Parliament either declining to pass laws, including amendments to the Constitution, or Parliament passing laws that may not be popular to the government of the day, we will have gotten back the parliamentary dictatorship that Article 257 was meant to curb. And then, my ladies and my lords, I go to the sixth era. and which was that the learned judges failed to consider or take into account the inbuilt fail-safe methods set out in Article 257 to ensure they always reflect the will of the people, and you are taken through by Mr. Oraro through this, I don't need to repeat at all. The seventh error that was committed by the learned judges is in failing to consider that the practice in other jurisdictions shows that the government is involved in popular initiative and is a widely accepted norm. And the best example that has been given is in the situation of Switzerland, which has provisions that are in pari materia with ours. We have covered that extensively in our written submissions, where we have shown that, in fact, in Switzerland, majority of the motions that were introduced by the government and were supported by the people, and therefore the popular initiative has worked in those circumstances. The eighth error is this, and it's a critical one. If you look at the judgment that the judges started with referring to, which is, you'll find at page 141 of the judgment, page 145 of the judgment.
140?
Page 145 of the judgment. It's paragraph 155. Is the case of the Speaker of the Senate and another versus the AG and 4 others. And what the learned Justice Mutunga said was this, that the court must also remain conscious of the fact that constitution making requires compromise, which can occasionally lead to contradiction, and that the political and social demands of compromise that mark constitutional moments fertilizes vagueness in phraseology and draftsmanship. It is to the courts that the country turns in order to resolve these contradictions, clarify draftsmanship gaps, and settle constitutional disputes. In this case, the burden was on the petitioners to show what were the contradictions in the phraseology of Article 257 that needed to be resolved. What was the draftsmanship gap that was available in Article 257 that needed to be resolved? And the position is that there was none that was identified. Therefore, the court embarked on a frolic of its own in answering a question that nobody posed, because those are issues, as the Supreme Court said, where you now start referring to the canons of interpretation is where there is a gap or there are contradictions. None were identified. Now, I promised to come back to this question of the president being involved in the popular initiative route. But I've already said that the president has the rights, like any other Kenyan, under Article 38 to participate in the political discourse, including to support or campaign for any cause. My Lord will also realize that the president is nominated by a political party under Article 137 of the Constitution. He is again entitled to support any cause that the political party supports, and therefore he cannot be faulted for participating in the popular initiative as suggested by the learned judges.
I have a small concern regarding the timing of my learned senior, Mr. Karori's time. I noticed the time, I just read time is up. So I don't know whether the court is monitoring his time for the sake of equality of distribution of opportunity.
Thank you very much. We are. In fact, it is going to 1:30. My understanding, when our senior counsel, Mr. Oraro, was addressing the court, there was only 2 hours that had been provided for Mr. Ogeto. Mr. Ogeto decided to apportion his time to various counsel to address different issues. I was going to tell Mr. Karori, who is on his feet, that you have 10 minutes to finish by 1:30. I understand you say that there is a respondent who will want to donate his 30 minutes or so. We do not know who that is. We have not been involved in negotiating that time issue. So I take it that you are now finalizing everything insofar as the AG's arguments are concerned.
My Lord, first of all, there was the 30 minutes that we had indicated that the the President's team had volunteered or had offered us. And then I have 2 other parties who have offered 20 minutes each. There is Ndegwa Njiro for the 43rd respondent, who is donating 20 minutes. Then there is Njoki Mboshe for the 45th respondent, who is also donating her 20 minutes. So that is just about an hour.
The court needs to be involved in these kind of time negotiations because we have set in our direction specific time periods for each party. I see a council raising his hand there. I don't know whether he's agreeing with you or not. But you proceed, you must stop in the next 10 minutes. It will be 1:30. And we may have to revisit the issue of time allocation, which we gave. We do agree, yes, the issue of basic structure that was covered by Senior Counsel, Mr. Oraro, is very important. It took a long time. But we cannot have kind of an open-ended time frame.
Okay, my lord, so do I take it the court, my lord, will not be allowing me to utilize the 30 minutes donated by the president's team?
You know, Mr. Karori, if you were to take literally the direction that each party to have 2 hours, and we have about 70-something respondents, you can see the danger we might fall into. And I think the president is directing you and all of us that really any such time negotiations need to be referred to the court for us to see what you do. After all, why should that benefit necessarily be yours and not of the court, you know? Yeah. So you need to involve the court about these things and wait to be guided.
No, I agree, my lord, except that for the first part, the 30 minutes, we had informed the court at the very beginning. That had been indicated at the very beginning.
And again, all counsel must remember that we specifically allowed voluminous submissions to be filed, about 40 pages, so that we take not more than the allocated time for highlighting. But we seem to be widening the scope. So please finalize your submission in the next 10 minutes.
Thank you, Madam.
Identify yourself for record purposes.
My Lord, the President of the Court, my name is Nelson Harvey.
Yes.
I appear for the first to the fifth respondents in the consolidated appeals. My Lord and my ladies, it is my humble request that the court sticks to the timetable and the direction that we were given. The reason is this. Before the High Court, there was a set number of parties who submitted as petitioners and respondents. Some of the parties before the High Court who never participated before the High Court and are now respondents cannot arrogate to themselves the distribution of time by allocating their time to a number of the respondents here. And let's be practical. The respondents number over 85. Is the court going to give somebody who never spoke before the High Court 2 hours before the Court of Appeal so that those 2 hours are donated to one of the respondents? I do not think that is what was the intention when directions were given. When in actual fact, during those directions, the appellants were limited to 4 and the active respondents were not more than 10. It is my plea that you confine the time that has been allocated to the 4 appellants.
I hear you, Mr. Harvey, and it makes a lot of sense. In fact, we know those who have filed submissions, and those are the council or the parties that we are allowing, or we shall allow some time to make some comments on the same. So as you finish, I was saying that when we adjourn, we are going to relook at the issue of time allocation. I do appreciate that there were quite a number of interventions made made from the bench, and the questions needed to be answered, and that took a bit of time. But we still need to be involved in that question of time donation.
Yes, my Lord, may I say with your kind permission that the time that I'm referred to was donated by one of the appellants. the President's team is one of the appellants. So the half hour that was donated to me, my Lord, with respect, would still be available, because otherwise it would be taken up by the President's team. So while there might be issues regarding the other appellants, but as regards His Excellency the President's team, my Lord, they have 2 hours, and they have donated half an hour to me to finish my submissions, because a lot of what I wanted to say, a lot of the time that was available to me, has also been taken up by the interventions, which are very crucial because they assist the court in better understanding the issues that are before it. So I'm not taking more time than what has been donated, which is the 30 minutes that the President's team has donated to us. And that is why, so that I can be able to cover another very key area, which is the creation of the constituencies. Because in 10 minutes, I can only finish the popular initiative issue. I need to deal with the creation of constituencies, because it's a significant issue. And so I request, my Lord, if it will be necessary to break after 10 minutes, I'm happy to wind up on the popular initiative issue, and then when we resume, I can then take up the remaining 3 issues within the 30 minutes.
It is now, I think, 3 minutes to 1:30. We'll not sit beyond 1:30. May I suggest that we know how long you require to cover those issues, and
Yes.
we will determine the amount of time that we shall give you when we return.
Yes.
Yes.
My Lords, I think within the 40 minutes, I'll be able to finish the 10 minutes that are remaining on the clock, plus the 30 minutes that were donated. I will not go into the other times that have been donated by the other parties.
Just hold on.
Why don't we adjourn now? It is almost 1:30. Then we come and we address the other issues that remain.
Yes.
Ask them whether we can adjourn now, and then we.
Yeah, Mr. Karori, before the President addresses you, as he has mentioned, the reason why we granted the parties greater latitude to do thorough submissions is that we are going to rely on the submissions, and what you need now, because you now have a clear appreciation of each other's arguments for and against your positions, the positions you have taken here. Just highlight the salient areas where you want, as you have pointed out, the errors, where you need us to internalize in order for us to understand the case as it is, and so that we can come up with a sound judgment.
Okay. We want to adjourn. Mr. Tindamolo, you are on your feet. What's the issue?
Hello, my ladies. Just on that issue, perhaps to assist the court, only 2 quick points. Only 2 quick points, my lord, my ladies. One, which is not coming out so clearly from my learned friend, Mr. Karori, is that as appellants, having been directed that we each have 2 hours, we sat and agreed on how those who might not want to emphasize certain points could cede ground for others in line with your directions, that if a point has been made, then subsequently it should not be emphasized. And that is the context in which it was agreed that the lawyers of His Excellency the President would donate 30 minutes to the Attorney General's team and 30 minutes to the BBI team. for the appellants. I quite agree that when it comes to the respondents, it might be a little more complicated. But my lords, my ladies, the second point, and my lords could consider this when you retire for lunch, is that sometimes there has been a practice that when there's an intervention only for clarification, then you could direct the clerks to stop the time running only for that clarification, and then they resume when the submissions resume. That way it's easier to hold one to the time that you had allocated. I just thought I would say that, man. Thank you.
All right, thank you. Thank you. It's a point well taken. Mr. Karori, we propose that we adjourn right now. And when we resume at 2:30, bearing in mind what our senior counsel Atenda Molo has said, we hope you will reorganize yourselves. We are going to look at the issue of timing again, considering who has filed what, and clarify that issue of time donation, because we must manage this time appropriately so that we are able to finish these proceedings by Friday. So we adjourn right now.
Yes, my lord. Maybe just my lord, if I may say, yes. as her ladyship has said, I've actually tried to make my arguments very brief and to the point regarding the errors that we have seen. So I will stick to that and try to finish it within the time that I've requested to be allocated by the court.
All right. Thank you very well.